Adam Hyland. We want to talk about everyone's friends, the retailers. And they're our friends because they love making the stuff we invest a lot of time and money in developing, and they love selling it. But there are ways to protect the design and the innovation around that. So let's talk about that, and how can you do it? How can you restrict the developments?
Yes. So, and as you've identified, in Australia, the retailers, the big retailers, have a lot of market power, and they are not only, for a company who makes food, for example, the retailers are their biggest customer, but they're also becoming their biggest competitor because of all the home brand products that they're putting out. And the home brand products are getting better and more sophisticated to the extent that they really are competing very, very directly with the branded products in terms of what they're delivering. And there's also an extent to which they tend to be sort of copying the formats, and they copy the innovation, and they copy the even the packaging look and feel that some of the branded products spend a lot of time and money developing. And so this puts the branded products in a bit of a difficult situation, trying to protect all this development, all this innovation that they've spent so much time and money to produce.
Can it be protected?
Well, it can be protected. Different things to different extents, but there certainly are some tools out there that can really be effective in at least trying to free up a little bit of space for your branded products and your innovation to survive against the challenge of the retail trade. It's hard for you to absolutely defeat the retail trade because they're always there, your biggest customers. You got to keep a good relationship with them, but there are ways of trying to keep them a little bit further away from your products for a little bit longer. There's a couple of perhaps underused parts of the IP system that can assist with that. So a couple of areas I'd like to talk about are innovation patents and also about design registrations, because I think these can play a role in really freeing up a little bit of space around your innovation.
Excellent.
Okay. So for example, an innovation patent, they're fundamentally like standard patents that everyone might be familiar with. They run for a shorter space of time, 8 years, but 8 years is a pretty good run for a retail product. They require a lower standard of inventiveness to get an innovation patent. And what they're really good for is protecting a lot of those incremental improvements that people make to their products along the way. The little subtle changes in the packaging, in the way the product's put together, in some, as long as it's something sort of technically or physically related to the product that actually helps that product deliver something better. It might be the flavour, it might be a formulation that actually makes it more crunchy or easier to digest or something like that. Lots of these little developments going on all the time, and they can be protected potentially by an innovation patent. Even down to such low-tech things as the shape of the product, such as the square English muffin we've got here. I remember doing an innovation patent on that a few years back. But there are other things such as, for example, this is a good one, the flat-bottom taco shell. Okay,
a favourite.
There, that's right. So as long as you've got a point of difference in a technical manner, so this is related to the shape. So, it's not an earth-shatteringly different idea, but it's got an advantage to it, and it is different from what had gone before. So when you've got something like that, you can get an innovation patent to protect it. And what that allows you to do is at least gives you a negotiating position against a retailer who wants to copy your product. It actually makes them have to deal with you in order to get a license or permission to use that idea if they want to use it. And if they don't, then you've got at least the ability or the potential threat of launching some kind of legal action against them to stop them from doing it. Now, how you play that, will depend on your relationship with the retailer. But if you haven't got it, you've got nothing to play with, and they can just walk in and copy it, and there's nothing you can say.
And they devalue your brand on the way through.
They do, that's right. And that's part of, I suppose, what they want to do is they want to make it look like their product is just as good as your product and it's cheaper, which effectively devalues the brand.
I know you've got one there that goes to the heart of most families, and that's pet food.
Yeah, yeah. So this one here is this was actually, I think, was the subject of a full patent, not just an innovation patent. But there's this is a cross section of a pet food kibble, which has got a soft centre and a hard, crunchy outer. This type of product, this is a new format. It's not necessarily something that's extremely technically different from what's been out in the market previously, but it's got enough of a difference. It's got enough novelty and innovation about it that it's the type of thing that you can protect. Things you can protect via innovation patents don't have to be things that are earth-shatteringly technical or extremely difficult or different. Just things that have got some kind of advantage to them that you think the marketplace will like. And if they are different, if they are new, as well as having that advantage, you can protect them. Okay. Another, what I think is a sort of an underused part of the IP protection system is design registrations. Now, what these are is basically a form of protection for either the two-dimensional design or the three-dimensional appearance of a product or a piece of packaging. They are relatively narrowly focused on the specific design that you actually put in and register, so you don't get a lot of protection around variations. You get some protection around variations of the design, but they're fairly specific to a particular appearance. But in a lot of cases, the appearance is very key to the success of the product. A very nice design for a piece of food or a very appealing packaging layout. People are going to want to copy it, and you do see it with again with the knockoff products from the home brands. They often go out and will try and protect. They'll try and copy the look and feel of your packaging, even though they won't use the same trademark because they know enough not to infringe your trademark rights. But they will do everything they can to make that package look like the package that's yours on the shelf. So someone who's not paying attention might just walk past and grab their product, thinking maybe it's your product, and it's part of the reason why they might do that. So in that sort of instance, a design registration on the packaging or on the product can really help, because what people are really trying to do is actually make people look twice at your product and their product. They're exactly the same. Why would I pay more for yours? And you can get design registrations on all sorts of things. This is a piece of pasta. This is a design registration in Australia for a dinosaur-shaped piece of pasta. This is a design registration for what would be familiar to you as a fairly well-known ice cream dessert. You can get design registrations on, here's basically a muesli bar with a particular shape. Here's an extruded snack product with a particular curl. You
mentioned that they've registered the inner parts of the curl rather than the whole extrusion, and I love that's the critical part, isn't it?
That's right. What's the proportions of the curl and how far does it come around, and the relative between the actual thickness of the piece versus the diameter of the curl, etc. That's what's being protected in this design. So someone who wants to avoid that design has to have something that actually looks substantially different from that. Some other interesting areas with design protection, there's a pet food snack that has particular qualities relating to the shape. So that's a very good use of a design registration. And this is a very interesting one too. You're seeing more and more of this, where a retailer will register the artwork on their pack as a design, take off all the branding and all the other information, the variety names, etc., and just register that artwork, because that is the type of thing that some of the retailers and some of the other competitors are going to try and do. They're going to try and make their pack artwork resemble your artwork, even though they might have a different brand name. And registering a design on that can give you a very powerful
tool. So a manufacturer
tool.
Registers that design.
That's right.
Yep.
So the manufacturer registers their packaging, their new packaging as a design, and that will gives you an ability to at least approach someone who's trying to copy your look of your packaging and say, you're getting too close to our intellectual property, you're going to have to back away.
It's a great place.
Yep. That's right. So these are some interesting ways you can actually use some of those parts of the IP system.
How do clients pick up on that? Do they need to call someone? And here's the unabashed plug for Frankie Hyland. They need to get someone and have a chat.
Yep, they do. They really do need to talk to an experienced IP professional, experienced patent or trademark attorney to decide what aspects of your product and your packaging can be protected and figure out the best way to actually protect them, because there's a fair bit of thinking that has to go into deciding what you're going to claim and what you're not going to claim, etc., to give yourself the most robust protection.
To give yourself the most robust protection, call Frankie Hyland.
That's right.
Super.